Good morning, good afternoon, good evening, depending on where you're logging in from. Colleagues, friends, speakers, on behalf of LAWASIA, I want to thank you all for joining this webinar, The Rule of Law Challenge in Bangladesh's New Era. So today's conversation comes in a context for the benefit of our international audience and those who have not followed the events in Bangladesh very closely. I'd like to give a brief introduction to the context. So Bangladesh, for the last year and a half, has been going through one of the most significant periods of political and institutional change in its history. Over a period of 15 years, from 2009 to 2024, the institutions that are meant to uphold the rule of law, the courts, the police, the prosecution, went through a long period of erosion. Judicial appointments and promotions became more and more politicized. Prosecution agencies were weaponized by the executive. The police operated often with impunity. Extrajudicial killings and torture became part of the country's vocabulary. And gradually, people stopped believing that the institutions could protect them from the executive, whose power increasingly rested in the hands of a single person. Then came July 2024, only weeks of protest, followed by violence and a total breakdown of order. Hundreds of people were killed. We saw state forces firing into crowds, even from rooftops and helicopters. When the regime finally fell on the 5th of August, law enforcement completely collapsed. Anger and revenge took over the streets. Police stations were attacked, homes were burnt. The Chief Justice's residence was ransacked. On the 10th of August, the Supreme Court itself was overrun by students, protesters, and the then Chief Justice, along with almost the entire appellate division, the highest court of the country, resigned. And out of that vacuum, a new Chief Justice took charge of the Supreme Court. A professor of law who was at the forefront of the movement became the law advisor, which is equivalent to the law minister. And the interim administration, led by Nobel laureate Professor Muhammad Yunus, took charge of the country. And for the first time in many years, there was talk again of large-scale structural reform in every institution at every level. But fast forward to November 2025, and many of us who had very high expectations have been slightly disappointed with how slow the reforms have been, how many promised reforms have not materialized, and perhaps most disappointingly, how new rule of law problems have crept up. But credit must be given where due. This transitional period has seen the introduction of a merit-based appointment system for judges of the Supreme Court, which is the first real attempt to bring transparency and objectivity into judicial elevation. There has been huge emphasis on separation of the judiciary from the executive. There is a proposed judicial secretariat, which is materializing. The expectation is that this reform would separate the judiciary's administration from the Ministry of Law and giving it control over its own staffing, budgeting, and management. These are not small steps. They go to the heart of how independent the judiciary can truly be from the excessive interference of the one-man executive we have seen previously. But they can also raise new questions. How much separation is healthy? If the judiciary becomes entirely self-governing, where does democratic accountability fit in? Also, even as these reforms move forward, some difficult realities remain. Several High Court judges who were seen as partisan or compromised have been stripped of their judicial duties in the recent months. Some have resigned. Others faced proceedings under the revived Supreme Judicial Council and have been removed. Hundreds of murder cases were filed in the aftermath of the uprising, naming hundreds of people in each one, naming figures linked to the previous regime, but alongside journalists, business people, and even lawyers. Many of these people are in custody, and bail is rare, and investigations are moving very slowly. At the same time, the violence that once defined state power in Bangladesh has almost completely stopped. Extrajudicial killings have ceased reportedly. Police excesses, which once made daily headlines, are now the exception, not the rule. And for the first time in many years, there have not been many credible reports of torture in custody. So we are in a strange but hopeful moment, trying to rebuild its rule of law institutions while being under such a time crunch as well, as elections in Bangladesh are coming up in February. Law and order and the economy are not in a great place. Members of the fallen regime are walking free in exile, issuing threats as well. So it has been a tough journey for Bangladesh. To explore all of this and more, we are joined today by four remarkable speakers, and I would like to introduce them to you. In no particular order, we have Sarah Hossain. Sarah Hossain is a senior advocate of the Supreme Court of Bangladesh and the deputy head of chambers at Dr. Kamal Hossain and Associates. With over 3 decades of practice, she has extensive experience in constitutional, corporate, and family law, advising and representing individuals, corporations, and non-profit organizations in Bangladesh and internationally. She leads the firm's pro bono practice and has acted as lead counsel in several landmark public interest litigations on equality, women's rights, disability rights, and freedom of expression. Sarah Hossain also serves pro bono as the honorary executive director of the Bangladesh Legal Aid and Services Trust, BLAST. In addition to her legal practice, Sarah Hossain is a professor of practice at SOAS, University of London, and an accomplished author on justice, constitutional law, and women's rights. She serves on the boards of several national and international organizations and is currently a member of the UN Fact-Finding Mission on Iran. Her contributions to human rights have been recognized with awards from the Lawyers Committee for Human Rights and the US State Department's Women of Courage Award. Next, we have Rashna Imam, barrister at law. Rashna Imam is the managing partner of Akhtar Imam and Associates and an advocate of the Supreme Court of Bangladesh. She is recognized by Chambers and Partners Asia Pacific and Global and the Asia Business Law Journal's A-list of top lawyers in Bangladesh for her excellence in corporate and finance and dispute resolution. Before joining the firm, she worked at Baker & McKenzie London and advising multinational corporations on mergers, acquisitions, and post-acquisition integration. Her practice focuses on foreign investment, corporate and commercial law, labor and employment, banking and finance, constitutional law, and arbitration. And she has advised leading multinational companies in high-value international arbitration and enforcement proceedings. Rashna Imam has also advanced public interest litigation in health rights, including reforms to emergency medical care laws, unnecessary C-sections, and organ transplantation. Her work has earned her international fellowships, such as the Asia 21 Young Leader in 2018 and the Global Program for Women's Leadership in 2019. She continues to play a leading role in legal reform and rights-based advocacy in Bangladesh. Next, Dr. Cynthia Farid. Cynthia Farid is a lawyer and legal scholar working at the intersection of constitutional law, governance, and political economy. She is an associate at Ergo Legal Counsel and a research fellow at the Chinese University of Hong Kong. With over 15 years of experience working in South and East Asia, she has advised on judicial reform, intelligence and security sector reform, international arbitration, and human rights compliance for institutions, including the United Nations and National Bar Associations. She is the founder of Global Scholacticism Project, which convenes networks of scholars and activists to advance structural justice. Her research has appeared in Law and History Review, the International Journal of Law in Context, and leading edited volumes, including Cambridge University Press. In 2023, she was one of the 5 finalists for the Einstein Foundation Early Career Researcher Award, selected from over 160 global research projects. Last but not the least, we have Greg McIntyre, SC, Senior Counsel. Greg McIntyre is an executive committee member at LAWASIA. In 2024, Greg McIntyre was president of the Law Council of Australia. Greg was also the president of the Law Society of Western Australia and a director of the Law Council of Australia in 2019, having been on the Council of Law Society for several years prior to that. He has been chair of the Australian Environment and Planning Law Group of the Legal Practice Section and a member of the Access to Justice Committee, National Human Rights Committee, and Indigenous Incarceration Working Group and Climate Change Working Group of the Law Council of Australia, and recently joined the Indigenous Legal Issues Committee. He has been admitted to practice since 1976. His early experience was with the Aboriginal Legal Service of Western Australia, the Aboriginal and Torres Strait Legal Service of Queensland, and as a sole practitioner in Cairns, and was president of the Far North Queensland Law Association in 1987. It's a real honor for me to have these speakers with us today. people whose work in different ways has consistently engaged with the intersection of law, justice, and institutional reform. Just by way of brief introduction about myself, I'm Saqib Mahboob, a partner at Mahboob & Company in Dhaka, where I head the firm's corporate and commercial practice. I work primarily in disputes, commercial, construction, and banking, alongside corporate employment and technology matters. I've been ranked by Legal 500 as a leading partner in dispute resolution. I'm currently also serving as an officer in the Asia Pacific Regional Forum of the International Bar Association, IBA. And I'm grateful to LAWASIA for inviting me to moderate this session today. So thank you again, all, for being here. Thank you to the panelists. And with that, let me start the discussion today with a question to Sarah Hussain. So Sarah, in the aftermath of the regime change, we've seen a surge of politically charged cases, the murder cases, now the surge in the anti-terrorism cases. Journalists, civil society actors have been jailed, have stayed in jail without bail. We were just, and you were representing one of these clients yesterday in court, and with an interesting turn of events eventually led to the journalist getting bail. So from a rights perspective, how could we have done things differently from a rights, due process, equality before the law perspective, and your views on that?
Thanks, Saqib. And apologies to everyone for my going in and out and with various backgrounds, having lots of tech issues running back from court. So I think maybe the first thing, before we delve into your specific question and where we are at now, I think, as you said in your opening remarks, we can't kind of underscore too heavily the fact that we're in a really transitional context and that we're not being able to address many of the very challenging issues about justice and accountability for the atrocities that we witnessed last year, unprecedented atrocities in Bangladesh's history post-independence. And we've also not actually as yet seen accountability in relation to the very extensive, gross human rights violations that took place over previous years under the previous regime and prior to that. So I think we have to be very alive to that being the context, and the fact that there's a real kind of bedrock of abusive process and due process violations that has been very much part, unfortunately, of what we've seen happening under different regimes in Bangladesh. So I think it's not realistic for us to expect that entire bedrock to be demolished overnight. And we can understand that that is something that is going to take time to build back, to build perhaps afresh a culture of human rights and respect for human rights. And I think we've also seen that during this year, there have been some significant attempts to address that past history. So, for example, we have seen the administration has dealt with the thousands of cases of abusive process, arbitrary detention, false cases that were brought against members of the political opposition in the past, as well as against civil society individuals, through withdrawal of criminal cases that were brought against them. We've also seen the judiciary being able to act in some of these cases in a way that they were not able to do. I mean, you mentioned the case we did yesterday of a journalist who's recently been arrested under Anti-Terrorism Act under this administration. But, you know, for 6 years, we battled a case of a world-famous photographer and activist who was, who was arrested on completely false charges. And we literally had to go, I think, to 7 or 8 different high court benches before we could get someone to actually give him bail. So I would say that we're seeing, at least I have seen in the cases I've dealt with, an improvement in that situation. You're not getting 8 separate judges being embarrassed in a particular case. So we have to understand that's the kind of bottom line that we're moving away from. We've also seen, I think, importantly, some really important judicial interventions in terms of these significant legislation that is, I think, really significant constitutional amendments, which also have created the situation we've been in. The 15th Amendment, 13th Amendment hearings that are going on currently. We've also seen changes in the laws. For example, the Criminal Procedure Code has been amended this year by the interim government, progressively incorporating guidance that the Supreme Court had laid down almost 10 years ago, which again, the previous government just refused to act upon and kept on trying to block. And, they lost an appeal and they tried to review it and so on. So we have got those, I guess, things to tick off as sort of, firstly, the challenges, but secondly, also some of the steps forward. So in that context, I think it is disturbing that we're seeing, I think we could have hoped for a more concerted effort to lay aside the legacy of the past. But instead, what we're seeing, one of the most criticized laws actually of the previous government was the Anti-Terror Act. And yet we're seeing that being repeatedly used. Not only has it been amended, to prescribe the previous ruling party and its activities, but we're also seeing it being used frequently for what I would say in many cases appear to be arbitrary arrests. In this week alone, for example, there's yesterday's case of this journalist who was, and several others who've been arrested under the Anti-Terror Act simply for attending a meeting, a public meeting, publicly notified, held in the center of the city, few yards from the Supreme Court, who was held in detention for almost 75 days now. Yesterday, we saw a child being released who'd been held under anti-terror laws for 1 month after being arrested on suspicion of being involved in an unlawful procession. So I think this kind of overreach of these laws, yes, it reflects the legacy of the past. Yes, it's the police maybe being trigger happy and responding. But yes, it's also a response to the fact that we are in a transition where the former ruling party has not given up its refusal to deny that it's been involved in any atrocities or human rights violations, where the story of human rights violations for them starts on the 5th of August, doesn't go backwards. So I think in that context, what we may be seeing as human rights advocates and lawyers is not the same as perhaps as what the public is seeing. And for us, I think there are three urgent things that we need to do. One is, as I've been trying to do, I think, try to explain why these patterns are repeating themselves and understanding how we need to address these issues consistently, understanding the past and the present together and making that clear to everyone that what we didn't accept for the past, we should not be doing in the present. But then in terms of actually how do we resolve it, I think we have to confront very clearly and have, the authorities be much clearer on not clarifying that you cannot make arrests like this where there's absolutely no evidence whatsoever of the allegations that are there. That is not how our police operate. That is not how our prosecutors operate. And one of the big institutional challenges is the prosecutors are not, even now really, we could say, even though it's under an interim government, prosecutors are largely appointed in terms of their political alliances or allegiances. And that means that they're, because of this extremely divided, polarized political context from which we're emerging, it means that those political enmities are played out in their decisions, and they're not necessarily acting neutrally in most cases, almost certainly not in most cases. And while we're seeing there's an interim government in place, but the magistracy also, I think, again, and the judiciary also, because of its history of complicity, in so many cases of turning a blind eye to clearly, arbitrary actions taking in place in front of them, rather than necessarily correcting their role, are simply flipping the way in which they operate. So I think what we need is for the judiciary to feel much more confident that they can act neutrally and independently in this situation. We have seen, I think, disturbing situations recently where members of the judiciary in the Supreme Court have been questioned about why, for example, they've granted so many bails, as it's been said by our law minister, law advisor, and why they've been questioned and asked to give information about why they've given so many bails. Equally, questions could have been raised of the judges who are not giving bails. Like, why are they not exercising their powers to give bail when they should? And I think we're really lacking, and I think it is because of this very fluid, very complex transitional context that we're in, we're not having the kind of robust conversations on that we should be having as a society. And particularly given that we have people in important roles now who have had a real, experience and history in our human rights movement in Bangladesh, I think we would expect to have much franker conversations about these issues. And we would expect that, I think, particularly with the judiciary, to see more initiatives being taken to ensure that judges can act independently in this context, and that the experience we're seeing of again false cases of people being harassed through being named in these murder cases relating to the July atrocities, and also in the anti-terror cases and Special Powers Act cases, we would expect much more scrutiny, I think, from on high. Just on the last point on that, we have seen this year that the interim government has taken many initiatives to set up reform commissions to look at a number of different issues. There was a reform commission on the judiciary, amongst others. But I think what we really needed was a reform commission. We still need it, I think, that deals with justice as such, the delivery of justice, not just with the judicial reform process in terms of case management and other issues, but dealing with justice and dealing with human rights and putting that at the center. That's not something we've seen. And I think we urgently need to see that kind of initiative as we move forward, and hopefully positively in this transition.
Thank you, Sarapa, for adding so much more to the context, and I think that really, the fact that the history of human rights violations and that culture of violating human rights in this country has become so normalized that sometimes even an interim administration which comes in with that mandate of reform can't. It's very hard to get out of that, and these actors in government it's for them it's so hard to create new processes that move away from that, and we are seeing that in practice now. So if I may bring in Rashnapa the next, and so Rashnapa, just to add a little bit more context, when the July movement was happening last year, as we know, there was also a case on that very issue in the Supreme Court, and yet the protesters, the students who led the protests, completely refused to engage the court, and they refused to be added as parties to the proceedings. They had absolutely no confidence in the system or in the court's handling of the matter. So much so that they didn't even appoint a legal counsel to represent their cause in the court, and instead chose to go to the streets, which I would say was reflection of a crisis of confidence in the judiciary. So now that the judiciary has taken on a multiple number of reforms, including with the appointments process, now with the secretariat coming up. So how do you see that the current reforms delivering on the promises of the July movement? And would you say that the judicial system today is a more accessible and transparent and fair forum for litigants and lawyers?
Thank you very much, Saket, for that question. I would like to start with the context. I know you've already covered the context and touched on some of the important aspects of judicial reform, but to drive in the point, there are certain things that I would like to start with. For example, as we all know, over the last 15 years, during the Awami League regime, the judiciary was systematically politicized. We saw judicial appointments on the basis of political allegiances as opposed to merit. And not only that, I think any attempt on the part of the judiciary to assert its independence was met with downright abusive and draconian measures. I mean, I'm talking about the 16th Amendment judgment, which reinstated the Supreme Judicial Council, which was met with forced resignation of the previous Chief Justice and him having to leave the country. So I think these were massive steps backwards so far as judicial independence is concerned, and this is going to hang over the heads of future chief justices, and it's going to take a very, very long time to actually come out of that. So this is literally where we started from post uprising. So my expectations, I think we have to align our expectations with where we started from. I mean, this damage was done over 15 years. So it's unreasonable to expect overnight changes or even significant changes. It's been, what, 1 year or so? But having said that, obviously things could have been done better. There's no doubt about it, but significant steps have already been taken. And for example, what you've already mentioned, an ordinance has been passed. One of the most criticized aspects of judicial appointments on the basis of political allegiance. So to address that problem and to remove executive influence from judicial appointments, this ordinance was passed last year. While this ordinance may have its share of problems or kinks, which will have to be ironed out, but it's definitely a move in the right direction. I mean, establishing an independent body to suggest or shortlist, rather, judges to be appointed to the Supreme Court, and that will be carried by the Chief Justice to the President. And based on that, appointments will take place, is definitely a move in the right direction. Of course, questions have been raised about different aspects of this ordinance, as in to what extent this successfully ensures that there is no political interference in the appointment. For example, I think the Attorney General's position in the appointment council has been questioned, because the Attorney General is the chief legal officer of the state. So perhaps there still remains scope for executive influence. And there are other aspects as well. We know that the senior most judge of the High Court is also part of this appointment council. And when it comes to considering candidates for elevation to the appellate division, there's likely to be a conflict in this position as well. So there are issues in this ordinance, no doubt about that. And I believe it has been challenged by filing a writ petition as well, constitutionality of certain sections of this ordinance. However, the High Court division disposed of the writ and wanted to keep the ordinance as it is for now, so that it can be taken up by the next elected parliament and perhaps the kinks ironed out. I think overall, this is a move in the right direction. However, we still see examples of executive interference pretty regularly. I mean, Sarapa has already covered one, but like sending mobs to the Supreme Court to insist on or demand removal of judges, for example. It is widely believed that the executive had a role behind that. This is a direct interference on judicial independence. And of course, the law advisor making statements as to how a judicial discretion of granting bail should be exercised or not, and not making statements about judges not granting bail. Again, these are direct interference and in the judiciary, things that we expected not to see under this regime. So there are problems, and I think it's going to take a while before we can reverse or undo the damage that has been done. And I think culturally as well, it's deeply entrenched. I mean, even if there is no direct interference in any particular court decision, because of the past history, it's difficult for judges to even give verdicts without fear of consequences, especially since we saw a sitting Chief Justice being dragged down and literally thrown out of the country for giving a judgment which is known to uphold the independence of the judiciary. So I think issues like that, they still persist, and it's going to be a while before we can actually see any meaningful change, but steps have been taken. So that itself is a move in the right direction.
Thank you, Rashnap. I think lots of points have been raised, and I won't make my question long to Cynthia. And if you could respond to any of those points that I see you nodding and sort of agreeing or disagreeing, I don't know. This is, well, please do address any of the points that Sarapa and Rashnapa have raised. And I also wanted to get a sort of comparative perspective from you, if you could shed some light on what lessons from other jurisdictions perhaps might guide Bangladesh in making the changes that are currently happening credible and lasting. And if you could also shed some light on what we could have done better.
Very big questions. No pressure, Saqib. Thank you. I mean, you know, the previous speakers, I was nodding along because I was agreeing with what they were saying. And I think they've also highlighted, you know, critical issues of integrity, also somewhat design of the judicial reforms that are on the table. I think that These are broadly positive. Of course, there are some kinks that need to be ironed out. But they are, I think, one step towards bringing Bangladesh closer to established international practices. I mean, you know, if we look at India, the collegium system offers some insulation of judges. But since you've asked for comparative, I'll start with that. But you know, there's been issues with that about transparency of how that process works. You know, Kenya and South Africa, they try something completely different. They integrate civil society representation into their judicial commissions. And I think that adds a popular dimension, which I think gives the process some credibility. And unrelated, but I want to bring up the UK only because they went through major reforms in the mid-2000s, only to highlight that, you know, even the metropole, right, the center of the Commonwealth, if you like, even that needs to change and tweak judicial independence and rule of law, right? Because rule of law and democracy are not static. These are dynamic, and things flow, and sometimes it's democratic, sometimes it's not so democratic. So in terms of design, I think these are all very good directions, but I think that for Bangladesh, the issue before us is not design, it's legitimacy, right? So reform can look completely flawless on paper, but if the institution that is implementing it is not trusted, then we have credibility issues. And when I think the Supreme Court was surrounded and effectively besieged last year, some of it sure was political theater, but I think it was also a verdict on public trust. People weren't necessarily rejecting the law, but they were rejecting how it has functioned, right? So there was some ground to make that accusation. In particular, I think the criminal justice system itself, in addition to some of Sarah Hussein's interventions, I want to mention that, you know, 70% of our prison population, this is some recent data from earlier on in the year, 70% of the prison population are under trial prisoners, right? So that gives you a picture of how things are working. And in addition to these unfair processes, the system itself is extremely inefficient. It's extremely slow, extremely inefficient, and these are things that need addressing over the years. Judicial independence in and of itself, it doesn't need to be re-articulated, right? It's already guaranteed in the Constitution. It's been reaffirmed in a landmark judgment. The problem is not constitutional recognition. It's the failure of implementation, failure of political and administrative will, really. The blueprint is there. The other thing is these big reforms that we're considering. The budget for the judiciary has been historically between 0.3 to 0.4% of the national budget. And so if we are trying to set up a secretariat, we also need to consider the bureaucracy, how that's going to be managed. You know, there's a lot of data that come from trial courts, lower courts up to the superior courts, and we make no use of this data in terms of addressing inefficiencies that exist in the system. And I just want to say that, you know, across South Asia, historically, judiciaries are expected to carry the full weight of defending the rule of law. And I think that that's kind of an unfair burden because courts are part of a constitutional ecosystem, not its only guardian, right? So when other institutions like the parliament, the executive, the bureaucracy, and I would say even the legal profession, right? So when these institutions are abdicating their share of responsibility, judicial independence really becomes, we over-romanticize it, but it's also under-supported in many ways. And the rule of law is not only the judiciary's job to uphold. I think it's a collective enterprise. You know, we have to look at governance, professionalism, public ethics, and that wider frame, I think, is essential if we want independence to mean something beyond the courtroom. And just a quick final to wrap it up, I want to say that public anger has been intense. It's somewhat understandable. People have watched the law used to delay accountability, right? But now, when lawyers emphasize procedure and constitutional reform, it often sounds to the public like obstruction, as if we're obfuscating issues on the table, right? But that perception is also dangerous, right? So if you remove the law, then you have arbitrary rule. And so what do we do about it? So the challenge, I think, now is for the legal community to make legality meaningful again, right? To show why due process is important, and it protects citizens, not just institutions. So we need to look beyond the judiciary, and I think independence doesn't operate in isolation, and we need to look at the wider ecosystem, the prosecution, the bureaucracy, the bar, all of which are going to shape how justice is experienced by the wider citizenry. Thanks.
Thanks, Cynthia. I think you raise a point that is very rarely raised, which is like that the fact that independence of the judiciary is not just about the judiciary, but the stakeholders like lawyers, like the lawyers associations and the community of lawyers. And I think there has been very little introspection in the legal profession. Every institution has faced scrutiny after the July uprising, but I don't think the legal profession itself has faced much or discussed much amongst itself as to how it had played a role in the sustaining of autocracy over 15 years, how it has had, how it should change and how it should learn from the mistakes that were made in those years. And I think that's a great segue for me to go to Greg McIntyre as a leader of lawyers, both in Australia and now holding an important position in LAWASIA. How do you, Greg? I would ask you, drawing on also on your experience as a rights lawyer, a very important rights lawyer and a LAWASIA leader right now. What practical role can lawyers and like professional lawyers' bodies play in anchoring reform and sustaining rule of law? How you see that, and also if you could shed some light on if you see any parallels between Bangladesh's current reform movement and other jurisdictions that are emerging from political capture.
I think lawyers, and particularly bar associations and law associations who have a leadership role, have a very important role in convincing the public that the rule of law is the only way to maintain a democratic process and to maintain fundamental human rights of the citizens. In the citizen democracy, as we can see from the Bangladesh experience and many others, is a very fragile concept. The concept of actually accepting that judges are to be respected and what they have to say is to be followed. I mean, that judges sitting in a court can say whatever they like, but if the executive government, the police, the military, the population don't do what it is that they suggest should be done, then the system doesn't work. And I mean, Bangladesh, of course, is not alone. I mean, we've seen similar things happening just recently in Nepal, with the courtroom being burnt down and all the court records destroyed. The Philippines has a very tenuous grasp on the rule of law with its most recent president. Myanmar, of course, has a military junta effectively managing it. Pakistan is going through the process of prosecuting its previous leader. Malaysia did the same. The US, I mean, the US courts are experiencing the executive government in the US saying, well, we won't necessarily do what it is that the courts have said we should do when the courts bring down rulings. So that we are seeing across the globe how fragile that is. We as advocates for fundamental human rights and advocates for maintenance of a rule of law, which prevents countries from descending into chaos, have a very important leadership role in explaining to our constituents and the population in general why it is that a democratic process with a separation of powers between the executive, the judiciary, and the legislature is the better way to go, and that it is possible for those institutions to actually deliver justice and to deliver fundamental human rights. I mean, the panelists, and particularly Sarah, I see, is still in her robes, having rushed from court. You're doing it every day, and you're explaining at a public level why it is that we need to be governed by rules rather than governed by the arbitrary decisions of men and women with their own self-interest only at heart. We need to rise above the concept of self-interest and maintain a dialogue of fundamental human rights being maintained. And if people don't comply with the rule of law, that there are processes which are seen to be fair and reasonable and not arbitrary in order to maintain a cycle of acceptance that we are generally better off being governed by ideas and ideals rather than what's in the best interests of the next person with the most power, with the capacity to make a victim of the person with less power.
Thank you so much, Greg McIntyre. I would like to come back to Sarah Hussain, and if you wanted to respond to any of the any of the issues that have come up since you last spoke, please do. And I also wanted to ask, bring in your perspective on. So, rule of law obviously is meaningless if it doesn't stand up for minority groups, vulnerable groups, and you have extensive experience being the head of a legal aid NGO, which works with women's rights and works with several marginalized groups. So these groups often suffer the most in times of political transition. Do you see that? Do you see that have we been able to give those institutional guarantees? Have we been able to put them back in place in this transitional period of Bangladesh? Or is it in your perspective that we haven't really gone as far as we needed to, and we haven't really protected their rights and prevented the abuses of the past from recurring? Like your views on that.
Sure. I mean, just picking up from what others have been saying, I think a key point that's coming through from everyone is, I think, is the importance of the bar actually stepping up. Unfortunately, like everything else in Bangladesh for many years, the bar has also been very polarized. And we've seen how that has played out in the in this transitional period as well, with reprisals against lawyers, for example, who played a significant role in the previous regime. And in many cases, that extending far beyond those who played any particular role, but simply by their association with the former ruling party, they're facing victimization now. But we have to remember also what happened to lawyers in the past. I'm just repeating this. I know that those of us from Bangladesh know this, but since we have an international audience, it's important to hear. Saqib, I hope you won't mind my mentioning your experience. Your father is the president of the Supreme Court Bar currently, was a former candidate for office and has held office. I know that you, for example, faced repeated shootings on your family and yourself. And I don't know how many cases your father has faced, perhaps maybe in the scores, I'm not sure. But 25. I have met only 25, so low. Some people I've met who've had lawyers who've had over 100 cases against them under the past regime. So yes, many things are going on now, but we have to see what's happened to the profession as well, is why it's so divided and why it's so difficult bringing people back to one space. But acknowledging that challenge, And in fact, because of that challenge, I think it's very important. I think one opportunity we're seeing at this time, which I think is an improvement on the past, is we are seeing more independent lawyers, I think, expressing their concerns about what's happening. The gap is we're not really working with the collective voice, I think. You know, there are many different voices in many different places. And the kinds of things we're seeing even on this webinar, we're not saying as often in a common space and reiterating it until it actually gets through to somebody. And I think that really needs to be done. And that's something where our colleagues in other jurisdictions can also support us. I think what Greg, you just said is really important. All of the points you made, whatever context we're in, it's critical to reassert the importance of respect for rights, respect for due process. And I think what Cynthia has said as well is it's very important to explain why that's important. For many people, they're not willing to understand that. It just seems remote. And it seems when you talk about, I think I see some comments amongst the questioners as well, who are speaking in detail about the situation that is currently obtaining, but who were probably, I think certainly for some of them, extremely silent about the past. So when someone speaks up in that context, without saying this is something that we've seen before, it hasn't just landed from outer space suddenly this year, then there's very little credibility to those voices and people don't want to hear. So I think that's one thing we could try to do as members of the bar, is to play that role in bringing out because we have had those experiences in the past and now representing people or otherwise being subjected to harassment or whatever it was from whatever perspective. So I think building that space is crucial. I think that connects also to what you're asking about the situation of minorities. So if we recall, after the July-August uprising, we had an investigation by the Office of the High Commissioner for Human Rights, the United Nations, and they produced a fact-finding report this year, which looked at the period actually during the uprising and immediately after, from 15th of July to 15th of August. And they documented many of the reprisal attacks and other opportunistic attacks that took place following the 5th of August, particularly in the 3-day period when there was no government in office and the interim government had not yet been constituted, when there were very limited almost no law enforcement effectively on the streets, and sort of limited army deployments. So there were many attacks at that time on minority groups. And by minorities, I mean groups, religious minorities, so including Hindus particularly, but also Muslim minorities in terms of Ahmadiyas, Shias, not necessarily minorities, Sufi groups, who all faced attacks on places of worship, on their homes, in some cases on their businesses, faced intimidation. Now, we saw how those attacks were then depicted, particularly in our neighboring country, in India, by the media and the very pro-government media, which seems to be the majority of the media in India, unfortunately, at the moment, depicted this in grossly exaggerated terms as a Hindu genocide, for example, amongst others. These are entirely inaccurate and wrong. At the same time, that doesn't mean that things didn't happen. So we're caught in this binary between an effort to say everything that happened is an exaggeration by India, and on the other hand, not acknowledging what happened, why it happened, how it happened, and what we can do about it. There have been some cases instituted with regard to cases of violence against minorities, but the reality is really very harsh and needs to be acknowledged, which is many people who don't feel secure, who feel threatened because of their identity, whether it is their religious or community identity or their political identity, which in some cases may overlap and intersect. They don't feel safe seeking justice. So even though cases may have been instituted, they may feel they don't want to come forward and give evidence at the fear that there will be further reprisals. They may be further targeted for speaking up or for seeking justice. So again, in that context, I think that for us to expect, we should demand and expect justice and accountability through legal processes, absolutely. But we should also understand what it takes to get there. And it takes building community solidarity. So I think the most important step in my experience with colleagues in BLAST, for example, and in other civil society organizations, is people are really focusing not only on documenting the kind of incidents of violence that are happening and threats, but trying to stand in solidarity with those who have faced these kinds of threats, to try and restore a sense of confidence, and to say, no, this is not a country that has now become, it's not become an Islamic republic, as there are efforts to depict it as by members of the former regime as well as their allies, overseas. I think we're not there. If we were there, we wouldn't all be speaking on your panel, for example. It's a very different space. It's a space where there is very hot and intense contestation going on about where we are going to emerge as a country. Are we going to, I think there's a consensus you want to respect democratic rights. But how inclusive is it going to be? How much respect is there going to be for pluralism? Are we going to hold on to our secular values and foundational values, I would say? Those are hotly contested issues, and we have to fight it out politically, I think. And there's a role there for the bar as well, to make the political arguments as well as the legal arguments about where we should stand and how we should respect rights. And I think that's the work to do, work outside the courts in building that dialogue and providing that solidarity and standing against those who have an image of Bangladesh as a communal or sectarian space, which is about majoritarianism and about exclusion.
Thank you, Saraba. I think one point that I would take to and ask a question to Rashnapa on the basis of that. Or you said something. You said that there is no collective voice of the independents, and even though there are lots of voices in the bar who are speaking out, who are filing public interest litigations or doing their own activism in their own way, but there is no collective voice, and the bar, perhaps being being polarized as it is not being able to represent that voice. Rashnapa, you have been involved in public interest litigations where you have played a role as a petitioner or the petitioner's lawyer, and advanced that as advanced causes from the legal community. How do you? But obviously that those are, every PIL is issue based and it addresses a specific issue only. But apart from PIL, perhaps, do you see any other way of reaching that collective voice for the rule of law, for a efficient, independent justice system, for rights of minorities? What role can lawyers play as for accountability, reform, and how can they fulfill this civic responsibility, you think?
Thank you, Saqib. After periods of political dominance, such as the one that we saw when the Awami League regime was in place, many Bangladeshis have stepped into the vacuum that was left by weakened institutions. But having said that, I think Sarapa has already covered it as a view that there was no collective voice from the bar. I mean, in moments like these, say the dark times during the uprising, there was no collective response from the bar leadership. And as we all know, and some of us were actually part of the team that filed the litigation, the public interest litigation, asking the court to direct the police not to shoot at peaceful protesters. Even that was an effort by a small group of lawyers. And that is unfortunate. That is unfortunate, because that is where I think the bar leadership should have also stepped in. And the problem, again, which we have covered by now, is politicization of the bar. And the bar has always been so politicized, and they became sort of extensions of party politics, and making it very difficult to present a unified front to defend our justice or rights or anything of the sort, which is what the role that the bar leadership in particular should be playing. And I think depoliticization of the bar is something that we need to explore. And especially after the uprising, there are colleagues who had allegiances to the Awami League regime, and they have practically been banned from appearing in court cases or practicing at all. And that is something that we don't want to see in the legal profession. And that is something that is not going to bode well for the legal profession. It's going to stop us as members to sort of realize our full potential as a pillar of civil society. And unfortunately, we still have not. I mean, we've seen individual efforts, we've seen some institutional efforts, say from NGOs like BLAST. But overall, collectively, there's been very little effort. It has all been party politics, even at the bar level. So that is unfortunate. And again, I think it's time that we reclaim our professional independence. And I don't know how we're going to do about it, given how deeply entrenched and polarized the bar is, even at this point. But also building coalitions with civil society may be a way forward. I mean, coalitions between bar and the civil society, as opposed to individual lawyers and civil society coalitions. If the bar leadership could take this up, and not just the Supreme Court bar, across the country. So that, and Saqib, I wanted to cover another aspect, which I think is critical. We were talking about judicial reforms and deeply entrenched behavioral patterns of the judiciary of the last regime. We've seen that the political parties or the government, the party in power would regularly throw political questions at the judiciary and, for lack of a better word, make the judiciary do the dirty work that can easily be done in the political arena. And I think that is where our judiciary needs to be assertive, put their foot down and throw the political question back at the government in power. And this has been done. I mean, recently I was in conversation with the Chief Justice of Nepal and the delegation that visited. And I think they have done this in an exemplary way in the last year or so, is throwing these questions back at the government, and that this is no space for political questions to be decided. And the case that comes to mind is the 13th Amendment case. The review petitions are still pending and ongoing. I mean, that was a political question. It was establishment of a caretaker government system, which had broad political consensus. That is not something that ought to have been thrown at the judiciary and its constitutionality challenged. And the judiciary entertained the same and went on to pass probably one of the most damaging judgments to democracy, as we saw what happened in the next 15 years and 3 successive massively rigged elections. So I think our judiciary needs to assert itself as well when these sorts of questions get thrown at the judiciary, and throw it right back. I know this is more related to the first question, but I thought making this point is relevant in the context of our discussion. Thanks.
I think all the questions are related. There's no way to separate them. It's funny that you use the word dark times for the bar, and it since my father's identity has already been exposed by Sarapa in this webinar, I want to mention a funny story, or I don't know if it's funny, but with the regarding the word dark times, because during the July movement, my father was at that time also the president of the bar, and he was going to make a press statement declaring that the Supreme Court Bar Association will give free representation to any protester who needs who has been arrested and needs legal representation. And he was in the Supreme Court Bar Association auditorium by himself because he was leading only a very small minority of elected members. The previous elections the bar elections having been massively rigged as well, leaving the non-ruling party aligned lawyers with a very small minority. And so he was doing this press conference, and at that time, and this was in the heat of the movement. I think it was late July, and some in control of the electricity supply to that auditorium switched off the electricity and put him in the dark. And he continued the press conference in sort of like the camera lights. I think that press conference is the clips of that are on YouTube, and and just reminded me of literal dark times during that time. I like to go back to Cynthia. And I think you were earlier mentioning, that the justice system obviously is not only the Supreme Court's to protect. And so in this, as we go to sort of this, hard separation now with budgeting and administration, etc., going towards a secretariat and the judiciary asserting itself, asserting its independence, not just in concept, but in practical terms as well. Does that create other problems? Does that create insulation of the judiciary? Does that create a problem of accountability? Now, if there's any issues that, if the public has any grievance regarding the justice system, they can hold the law minister accountable in a parliamentary system, perhaps. Who is then accountable to the parliament, etc. But when the justice system is fully under the administration of the judiciary, do you feel that there is an insulation and a lack of and a possible risk of a gap in accountability there?
I think that the structural separation is a welcome development, right? But people's habits, unfortunately, particularly in how the bureaucracy behaves and how the kind of coordination between the ministry and the judiciary is going to work out, I think that's something that needs to be tested. But I think that given the structural separation, that is something that they'll be forced to confront it eventually. I don't think it's something that we will see immediately. But in terms of also, I mentioned the prosecution service earlier, which is essential to judicial independence and essential to how now under the reform structure the judiciary is going to perform. And so, it's already been mentioned that these are all political appointments. I also want to mention one other thing is that ministries are not equipped with dedicated cadre of law officers. It's usually judges that have been deputized into these ministries, which I think ultimately hurts in how ministries operate, how bureaucracies operate. And I think it's also going to, it's going to be a test of time how the new structure is going to work out. So I think going back to kind of the bar conversation, because who enters the legal profession is as important in how we determine how it's going to perform, right? And so the politicization of the bar came up. I think the bar should be political to protect its own interests. Ultimately, it affects all of us, right? And so I think one thing that hasn't come up at all in this whole reform process is legal education. And it's uneven in Bangladesh, right? Many new lawyers enter the profession. There's not enough practical training. There's not enough mentoring. Some lawyers begin practice with structural advantages. You have access to better resourced universities, family exposure to profession, or you have mentors that guide you. But not everybody has that. So it's a uneven playing field because pathways into the profession is unequally distributed. Sorry to veer off from the main questions, but I think all of these ancillary things affect how the credibility of the justice system ultimately. And I think one thing that we also need to consider is representation. I don't think our audience should be fooled by the makeup of this panel, this sort of largely female panel. Women actually make up fewer than 10% of the higher judiciary. And so, recruitment, promotion, there are, class concentration there too. There's also patronage that works. So one irony is that if you look at 1990 and the role that the bar played and how the legal profession worked at that time, and then if you jump all the way to 2024, you'll notice that progressively, right, it's become much more political and divided. It's a microcosm of the larger political conditions in the country. And I think it's not good for the legal profession. And so representation, I think, is also really important, because if we're talking about inequality, it's really important, who's defining that inequality, who's making judgments on minority issues, right? Who's making judgments on issues that affect women. So broadening participation within legal institutions, I think, is also going to be central to restoring trust. But I want to go back to what happens to these reforms beyond this year. Right. So all of these reforms are now unfolding inside this constitutional vacuum, right? For lack of a better word, we don't have a sitting parliament. we have an interim government, and we have a legitimacy crisis. So if you look at Nepal and Sri Lanka, I know some people here in the audience are perhaps from there. And so one of the things that hasn't happened there, so there's also legitimacy crisis there. But one of the things that hasn't happened is that people haven't focused on, let's throw away the constitution, right? Let's throw away the baby with the bathwater. So that hasn't happened there. And the thing is, public energy on certain issues are finite. And so if you spend all of that energy into outlining these, we had 11 commissions. And so if you spend all of that energy in doing that without a plan as to how it's going to be implemented, that's also another crisis that we're going to face. And also everything right now is based on ordinances. So what happens in the first session? So these need to be obviously enacted within those first 30 days of the first session. So what happens if it doesn't? And how do we ensure that? So these are, real conversations that we need to have. I'm happy to come back if there are any other questions on this. Thanks.
Thank you, Cynthia. If I may go to Greg now, and I think Cynthia raised a very important point of representation. And Greg, I have to say I had a planned question for you, but if I may also pick your brain on representation, because I think it is a very important issue in Australia with the perhaps the Aboriginal community, and obviously a global issue is representation of women in the bar, in the bench. In the legal community, and how you have been in leadership positions for a long time. How have you seen that play out, or how have you addressed? Have you seen it being addressed in Australia and in the region?
Are you referring to the diversity of?
Yes.
The diversity within the profession and that kind of thing. Interestingly, in Australia, the female law graduates are now about 70%, as against 30% male, which is a significant shift from decades before. It's still the case that the more senior members of the profession are male, by a significant majority, but it seems as though we are progressing, at least in Australia and some other Western countries, into a generational shift. So that's interesting. There's a serious underfunding of legal representation for the most vulnerable categories in our society. We've had work done in the last couple of years identifying there are probably about 15 identifiable vulnerable groups who just can't afford legal representation. We do have a legal aid system, but it's really about a fifth of what is required in order for people to be properly represented in courts. Was that the kind of thing you were asking?
I was asking more about representation in the legal community. So, percentage of lawyers, you talked about percentage of lawyers are now coming in to the profession, but what about appointments to the bench, for example? Like in Bangladesh, we have women lawyers who come to practice but are not but don't perhaps survive a law for a long time in practice. And then when it comes to elevations to the bench, there is only a very small minority of women would be there. And the situation can be even more dire for ethnic minorities, religious minorities. So for them being elevated to positions of power or positions of responsibility within the legal and judicial community is quite, I would say it's not in a very good place. So I wanted to know, from an Australian perspective.
We don't have a broad diversity in the sense of ethnic groups or Indigenous groups. There are a handful of Indigenous lawyers now, members of the judiciary in Australia. But interestingly, in a number of states, the female judges are now around about 50%. And we've had quite a number of chief judges in the different jurisdictions. So they are struggling to get to the senior ranks of the profession, but there is a definite shift in the way government, and these are executive appointments in Australia. There, as soon as a female barrister gets to be senior counsel, she doesn't last very long as senior counsel because she's quickly appointed to the judiciary. So we are seeing quite a significant balancing of the genders in the judiciary generally across Australia. And I think probably New Zealand is similar.
Thank you, Greg. I think we only have about 20 minutes left. And if I may allow some questions from the floor. So we had a few questions that were posted by the audience when they registered. I went through all of them. I think a lot of them have been covered in one way or another. And please excuse me for not being able to go through all of them. But I currently I see a few questions in the Q&A box here as well. And if I want to take one question from here. One person here has asked, how can young legal professionals contribute to strengthening the rule of law? And the question was directed to Rashna Imam, but after Rashna responds, please, I invite any of the other panelists as well to chip in with comments.
Thank you, Saqib. Thank you for that question. I think we need to encourage young lawyers not to see themselves only as private practitioners, but rather some sort of public servant for justice. And this we can do by, some of it is already there, but by having clinical education as part of your LLB degree, by having moot courts, pro bono programs in particular, which I'm not sure if our public universities may have some, but the private ones probably don't. So pro bono, introduction to pro bono programs and the concept of pro bono work at an early stage in your academic life may go a long way eventually to sort of instilling that sense of responsibility on you, that and which you expected to carry on when you're practicing law eventually. And I think especially if you are in litigation, initial years will not bring in a lot of income, that's for sure. So I think it's, you even practically speaking, you can use that time to do a lot of pro bono good work that can have a positive impact in society, because as it is, you will not be making much money otherwise. So I think early on pro bono engagement, this should probably be tied to interning with law firms. I think the pupillage requirement that we have for 6 months, we can introduce it there as well, that a certain portion of that work has to be pro bono. So early on, pro bono engagement, and then eventually use your spare time, if you don't have any time at all, to do some good pro bono work. And that is how you can actually end up doing a lot of impactful work.
So Queb, can I say that young lawyers should maintain their idealism, keep their eye on the fundamental rights that we as legal practitioners are trained to pursue. And I mean, I've been doing it for nearly 50 years. You have to keep focused, and that can be an enjoyable part of life. Perhaps you won't be the richest lawyer in the world, but you will die knowing that you have done something worthwhile for the public.
Thank you so much, both. There is a question regarding, I think this has been covered a little bit, but the word political weapon has been used in this question. So I put this question to Sarapa. The question is, how can we stop the judiciary from being used as a political weapon by the ruling party? If you want to respond to that.
I mean, I think we've been making some start with the new legislation on appointments. But I think we need to also, as from the bar, if the question to us is as members of the bar, I think we have to observe certain processes and practices in how we critique the judiciary. We've been firm opponents of, the use of our laws on scandalization of court, which still exist in terms of the outmoded colonial legacy of contempt of court, that one aspect. But at the same time, I think we are going too far in the other direction of criticizing judges in an abusive fashion, irrational fashion, rather than looking at the process. So I think we have to exercise a bit of restraint from the bar on that, on how we engage with the critique. But I think that judges have to have a sense of, one of the things we could have had in the transition is we could have had a kind of, big reconstitution of the courts and a big vetting process and a sort of much more clarity on who played what roles. One of the unfortunate parts is we haven't quite had that. We have had some judges who've had actually rather distinguished careers as judges and made very significant contributions to our jurisprudence who are now still under question. We don't know exactly what will happen in terms of whether they return to the judiciary or not. At the same time, I'm sorry to say we do have judges remaining very much in office at different tiers of the judiciary, about whom there are very many questions. And you simply need to read some of the judgments and look at some of the orders. I'm not making random comments. But there doesn't seem to be an effective process of actually addressing that issue. So I think that while we need to secure the judiciary, we also need to continue to be looking very carefully at what is happening inside the judiciary. So the question that came up earlier, and there have been many comments about that in the chat box as well, is this issue around bail and not bail. It's a very fundamental issue about personal liberty. And we need to look, what is the track record of the courts on that? Can we set a benchmark and say, can we improve from where we've been in the past 15 years on that issue? Can we move forward? I think those kinds of, more sort of deeper questions are needed about how we will safeguard and create or establish, if you like, the independence of the judiciary, and not just stay tinkering with reform proposals, which are about case management and other more technical solutions. We have to acknowledge that there is this very deep malaise, and we have acknowledged it to some extent, but I think not fully. And I think not fully acknowledged also the kinds of pressures there are on judges. Rashna said it very well about the kinds of perception of threat that many judges have currently, but why they don't feel able to act in many situations. There's a sense of there may be a popular, mobilization against them. There's a fear of that, and there must be a clear position that that cannot be allowed under any circumstances. But we also have to be much clear about what are the processes that will be applied in these situations. Can I just say a quick thing, Saqib, about the young lawyers point? And I agree with everything everyone said. I think I really agree with Greg that we have to get young lawyers not, to pull on the good examples from the past, but to understand they're going to set really fantastic new precedents too, because, it's up to them what they're going to shape of our judiciary and of our courts and of our legal profession. And they have a chance now that, we didn't have 30 years ago, let's say. You can be a lawyer in all sorts of different spaces now. You don't have to be just a litigator, marching the court corridors all the time. You can be fashioning the law from outside. You can be working directly with communities. You can already have a role when you're a student. In fact, in Bangladesh, we've had this extraordinary student activism in this last year. So and people have played a part through their own roles already. So I think, explaining that the chances of changing the legal system and enforcing rights comes in all sorts of different spaces. It's about legal education. It's about opportunities for young lawyers, trainee lawyers. And there's a lot we can do at the bar in terms of, we can certainly demand that or ask for the Bar Association, Bar Council to maybe change rules so that actually doing pro bono work becomes one of the things that you do to qualify. You don't just pass your exams, but we can also set up units within the Bar Council to provide those opportunities. Organizations like BLAST and others can work and already do, providing opportunities for internships. But I think in the private bar, those of us who are in law firms, we could actually also provide, for example, funded scholarships to undertake pupilages in our chambers for people to do not just pro bono work, to learn good corporate work, good employment work, whatever it is you happen to be doing, but also, do some pro bono on the side. So I think we kind of need to put some material support behind this as well. It's very important that to acknowledge the kind of resources, because otherwise it ends up being privileged people, I would say, like all of us on this panel, who get those opportunities to do that kind of stuff, and other people don't get that chance because they have to earn a livelihood. So we have to kind of broaden this out and give more opportunities for many others to enter the profession and change what it looks like and what it does and says.
Thank you, Sarapa. Cynthia, do you want to respond to any of the questions that have already been said? I would, you know, we were talking about legal education, and this has come up now, the institutionalization of it, and which we have lacked. There was a remark yesterday. I was in the appellate division, and there was a remark by the presiding judge in court number 1, two elected officials of the Bar Council who were also appearing in other cases. And he showed his frustration. The presiding judge expressed his frustration at them and said, "You have made the Bar Council a voter registration center instead of a instead of creating lawyers, you are creating voters." And it might have been a sweeping comment, but that perhaps is, you know, I think it shows that the Bar Council has lacked as a body that had in the past provided and invested in legal education, and then you know, went to just holding exams you know, once or twice a year, and those exams have also been questioned as to how effective they are in actually finding the better lawyers. So yeah, if you can comment on this, since you already raised it before.
So I think I would probably concur with that particular judge. The Bar Council's role has been, I mean, it's a veritable black hole in many ways, and so I don't know if it does much other than the actual registration of lawyers, and it's supposed to be a regulatory authority in some ways. Even I think some years ago, I wanted to do a research on sort of disputes between lawyers and how the Bar Council disciplines lawyers. And I know there's a registry, but I think there was one comment like there's arbitration amongst lawyers, and then so none of these disputes are formalized and everything's sorted out with political leaders amongst the bar. So I don't know, I had some half response, so I didn't pursue that at that particular time. But I think even within academia, I don't know how much a lot of academics engage with actual judgments, or actual academics have bar licenses or have practiced. And so this is something I think that's worth exploring, and clinical legal education is always a good thing. But I think I want to close with something. In fact, this is something I'd read in one of Kamal Hussein's interviews, where he says, you know, we can't afford to pass on cynicism to the younger generation. And I think that's true. But then that means that we need to have an intergenerational pact, right? So we have to be able to guide the younger generation. And in some ways, the intergenerational disconnect also speaks to the larger problem that we had. I think that was a symptom of that disconnect. And so we just have to find, you know, our voices and create a collective. It's a tall order for the legal community, and things are broken, things are fragmented. But, you know, I think it's a beginning of a conversation. It's not something that's going to happen overnight. Thanks, Akib.
I would like to thank the audience for the very engaging discussion in the chat box. We haven't been able to address all of it. We're nearing the end of time. And I think I'm grateful for the audience for expressing comments, questions in the chat box. And I think Sarapa has mentioned that she was looking at the chat box. I definitely was. I've read all the comments. But since time is short, I would invite the panelists to have very brief closing remarks, and then we can go towards close of this webinar today. If I may invite in the order that I asked you to speak, so Sarapa first.
Yeah, I think closing remarks, let me think. One is, I think we would, firstly, thanks to LAWASIA for doing this, but I'd really recommend having more dialogues and maybe trying to encourage using this platform to have dialogues inside Bangladesh, but also connecting, I think, with other lawyers from the region, because the kind of problems that the questions you posed to me at the beginning about the use of this draconian legislation and so on, those are actually common problems in our region. You know, Bangladesh is at a particular historical moment, but some of the patterns we're seeing of abusive process are not new. And they're being experienced elsewhere as well. And I think it's very beneficial for us to kind of understand what's happening in a context. So I would really ask us for that. And I think another is for us to see how within the country we can come together more to create common voices on these issues. Because I think we need to address not only ourselves amongst the legal profession, but kind of speak to the public at large in sort of clearer ways about the importance of maintaining due process. I think that's not clearly understood for the reasons we've all said. It's not clearly appreciated, it's not felt in a very visceral way. And I think we need to make clearer to people through the kind of examples we all have at our disposal because of the work we all do, so we can build consensus on that.
Rasnappa.
Thank you, Saqib. I think I've said what I wanted to say. I would like to second what Sarapa has proposed, that this platform can be used for regional dialogues and inviting lawyers as well as judges to engage and compare notes on how to deal with problems, which, as we know currently, Sri Lanka, Nepal, they have gone through similar situations recently. So we can learn a lot from their experiences and how they're handling, and vice versa. And I think that will go a long way in avoiding some of the pitfalls that probably lack of such a platform led to. And I think my realization partly stems from the recent dialogue that we have had with the Nepalese delegation. I mean, a lot of the problems that the judiciary in particular faced is a shared problem. And had we had a dialogue at the right time, probably we would have been better equipped to deal with the problem. And of course, I think Cynthia mentioned about Dr. Kamal Hussein's observation that we should not pass on cynicism to the new generation of lawyers. I still think, despite the failings of the bar collectively, I still think this is a fantastic profession. I think there is tremendous opportunity to make a difference, to play an integral role in democracy and establishing human rights and promoting human rights at every level. And whoever's interested in this is the right forum. And as Sarapa has pointed out, that you don't have to be a court-going lawyer to be able to make the difference. There are many avenues open to you, and Interning at Blast is one of them, for sure. And I think Christabel mentioned in the comment box that if an element of pro bono work, a portion of pro bono work could be made part of the license that is given to advocates, that would go a long way in instilling a pro bono culture. So I wanted to draw that to everyone's attention. I think that's an excellent recommendation. And I think Sarapa has already covered it, but the Bar Council can have committees dedicated to public interest litigation, committees dedicated to human rights. And I don't think there is any committee as such. I mean, a basic human rights monitoring committee, or even a legal education committee. And they can involve or engage young lawyers to do a lot of the work for these committees. And that will be another way of engaging them early on and instilling this pro bono culture, or how they can make a difference in Bangladesh. Thank you.
Thank you, Rasnappa. Cynthia.
I think most of what I want to say has already been echoed. I think that in this particular moment, I think a lot will depend on how the next few months unfold and how the elections go, because I think there are quite a few lawyers that are now nominated, because Parliament in I think the previous decade and a half, there were hardly any lawyers, and it was a lot of non-lawyers. Even in this current moment, I think we have a duty to kind of claim back our space, because there's a lot of reform conversations and particularly constitutional reform conversations that's happening, except a lot of it is by non-lawyers, and it has turned into this academic exercise of, let's see what's happening in this country and that country, and it's worked here and it's worked there. And so, you know, context is also really important. So I think that lawyers need to claim this reform conversation back, because when you have these reform conversations in the populist arena, right, it's not necessarily democratic. And I think lawyers do know the value of the rule of law and kind of democratic conversations. So I think it's incumbent upon us, all of these things that we discussed and all of these, you know, we need to keep having these conversations. So I'm just going to leave it there. Thanks.
Thank you. Greg, your final remarks.
Yes, Akweb, the Philippines Bar Association does make it compulsory to do pro bono work in order to maintain their practice certificates. It's one of the jurisdictions, rare jurisdictions, which does that, but it's an interesting model. Clearly, organisations like LAWASIA and the International Bar Association have strong themes of rule of law as their sort of primary focus, and so please lean on them to provide support in Bangladesh and other countries to assist your profession, the profession in Bangladesh, to play its important leadership role in maintaining the rule of law. And of course, one of the other things which LAWASIA does is its educational function, of which this is an example. And if clearly it has an interest in assisting in Bangladesh as well as around the region to ensure that everybody, that lawyers are sufficiently trained to understand the importance of the rule of law and are supported in being leaders in that function, in maintaining the rule of law.
Thank you, Greg, so much. And thank you to all the panelists. I just wanted to thank LAWASIA for organizing this webinar. I would like to specially thank Mr. Shyam Divan, Senior Advocate in the Supreme Court of India, who has pushed me for a year to do this webinar until I agreed. And I also wanted to say to the participants who have joined today and who have, and this is perhaps for many of you, this is your first LAWASIA event, that LAWASIA actually does provide this platform for discussion and amongst jurisdictions. Only last month, the LAWASIA had its annual conference in Vietnam, and my colleague Rifat Rahman was there presenting a paper on, or presenting his views on the July movement and the aftermath. And I think the panel also had lawyers and judges from jurisdictions across Southeast Asia and the Asia Pacific. So there is a LAWASIA annual conference every year, and LAWASIA is I think brings together a lot of bar association leaders from the region, and those who are and there's always very insightful panels about rule of law, role of the bar, and issues that we have talked about today. So please do check out the LAWASIA events, and you know, they're all in the region, so it's always a short flight away. If you are, you know, if you want to attend in-person events, and then there's a lot of webinars like this as well, which are sometimes jurisdiction specific, but also sector specific and covering and also across jurisdictions as well. So you know, everyone who participated today, if this is your first time participating in a LAWASIA event, please don't make it your last. I've been participating in LAWASIA events for the last 6 years. I've been to 3 annual conferences, I think, and hopefully, you know, more in the next decades. So thank you so much to the panelists for contributing their time and effort in preparing for this webinar, in sharing your views, and thank you to the very engaged audience who you commented throughout the webinar. Thank you for your questions, and thank you again to the people behind the scenes, Magda and Shana, who helped put this webinar together with me. And thank you so much, and have a lovely day, the rest of the day. Thank you so much.
Thanks.
Thank you.